Mom always said, look both ways before you cross the street. Our mothers were right. In order to avoid danger, you first have to see it. But how do you avoid intellectual property danger? Fortunately, there's an IP tool for that. Welcome to IPY. IP disputes are messy and distracting, especially patent infringement. That can put you out of business real fast. So how do you look both ways before crossing the street? An IP tool called an FTO review can help. Freedom to operate, as in free from obstacles. We look for other people's IP that could prevent us from going to market, and whatever we find, we assess the risk and adapt as needed. Let's look at a hypothetical example, because no one publicizes their FTO reviews. Let's say we've got a new AI-based software as a service to index and search in video. Our system has three main AI components: a video object detection module, an object classifier, and a search indexing module. So we search the public patent databases looking for patents that could have any of these features. If our system has three features that could have patent risk, then we search each one at a time. Okay, so let's say after searching each of our main features, we didn't find anything like our indexing method. It's really important to our SaaS service, so we decide that we should file our own patent for that feature. But having our own patent doesn't mean we get to ignore all other patents. We still have to respect other patent rights, so we continue our review. And let's say we find two patents on image classification that are similar to our approach. They could be a risk. We don't want our classification module to infringe these patents. So we have some choices to make. An IP lawyer might determine that the patents don't actually cover what we're doing, meaning we're not likely to infringe these patents. We could steer clear of the problem by reworking our classification approach to avoid these patents. We could seek a patent license from the owners, but if they're competitors or the price is too high, that may not be possible. Or we could challenge the patents in court to knock them out, but that's expensive. Which one of these will be the best option will depend on the situation. Like I mentioned, it's critical to involve IP lawyers because the stakes are high with patent infringement. They should validate your search approach, possibly do some additional searching, and ensure that the patents that are found are properly understood. Our example FTO review located some potential dangers, giving us the ability to react. And even though it's a pain to change design or negotiate a license at this stage, that's nothing compared to the pain of an unwanted infringement lawsuit. But it's important to understand that no FTO will be perfect or definitive. More searching will always find more patents, and sometimes it's difficult to quantify the risk that a particular patent poses. So think of an FTO like a risk gauge that provides information you can factor into your plans. I know this is a lot of information and it's just a short video. There's a guide on the IPY webpage to get you started. And by the way, if you've done an FTO, your credibility with investors goes way up. FTOs are essential for every tech business, even if you don't plan on filing your own patents. And using this tool with trademarks will also help you avoid trouble with your brand ideas. Looking both ways before you cross the street isn't just wise, it's one of the best things that you can do for your business. In the next video, it's time to jump into patents.